Good morning. I was told that I should use a microphone. I hope this suffices. Welcome to the CISG seminar at our faculty, and it's an absolute pleasure to open it, I think, on behalf also of Department of Civil Law. And what I want to say is that it's a rare privilege to have the CISG as the topic presented at the faculty by such a stellar number of speakers that we have today. And I'm not really exaggerating this. I'm not exaggerating because all the speakers that you will hear today are either members of the CISG Advisory Council or their rapporteurs, if I understood correctly. So it's very hard to overestimate the impactfulness of CISG Advisory Council and its work on the CISG during the course of decades now. So what you're going to get is CISG at its very best, and I think also at its most succinct manner possible. Students here and practitioners, I assume there are some practitioners at least in the audience, very soon realize how important CISG is for a lawyer in Serbia, I would say primarily. Some students get in touch with the CISG through the Vismut, and it all seems very academic, but once you step out, I can assure you a number of transactions that you're going to encounter, those of the sale of goods, are going to be the CISG. And it's very important to understand where the traps are, not to fall into the trap of thinking that something resembles a provision you have seen in your domestic law. Because CISG has its intricacies, and I think a crash course or seminar like this will be very useful for everyone here. We also have a very rare privilege that CISG Advisory Council is in Serbia for the second time. Either they liked it very much or they had no other choice.
No, we like it.
And I'm looking forward to this, and I'm going to devote most of my day, which I have a very light schedule, listening again to some of the topics I thought I knew. So we are coming to the first panel, which is moderated by my colleague, Marko Jovanović, and we'll start with him.
Thank you very much, Professor Pavić, for these kind and thoughtful words of welcome. I have the pleasure of introducing the first panelist in the first panel of today's seminar, and that is Professor Edgardo Muñoz López. Edgardo is the professor at Universidad Panamericana in the city of Guadalajara in Mexico, and his studies actually took him more or less all over the world, starting from Mexico and France, over the United Kingdom and the United States, and finally coming to Switzerland. And when in Switzerland, you can either choose to specialize in law of obligations and international sales law with Professor Schwenzer, which Edgardo did, or you can choose to specialize in sports law, which Edgardo also did. I will leave the topic of sports law for the coffee break, and right now Edgardo will talk to us in his capacity of authority in the CISG and a member of the CISG Advisory Council, and he will speak about the sphere and scope of application of the CISG. So Edgardo, whenever you're ready.
Thank you so much. First of all, thank you again for having me, for having the members of the CISG Advisory Council, and for this warm welcome to Belgrade, to Serbia. I'm very nicely surprised, which I shouldn't. It only shows my ignorance of this part of the world, because it's my first time here. But I have loved the place in every sense, especially the food and the people. So I have been given that, and also thank you to the authorities of the university for organizing this event, we think is very important because we dedicate our time to it. But we thank you for also giving us the chance to listen to what we have to say about this topic. And I was given the task of speaking about the CISG scope of application, and I prepare a presentation for that. I think is that right? Yes. So as you know, every legal legislative instrument has a scope of application. These are the first rule in the law, or sometimes actually the last, depending on the style of your legal tradition, that tells you to which cases this law applies. What does this law covers? What does this law governs? And the CISG, that is an international treaty, also has rules on that. And we start talking about the CISG with this rule because basically, if according to this rule, the CISG shouldn't apply, it doesn't make sense to continue with the rest of the provisions, right? We should probably go and see a different instrument. And as a type of introduction, or a sort of introduction, I will just speak briefly about the CISG. I know many of you are familiar with this treaty. CISG stands for the Convention on International on Contracts for the International Sale of Goods. You have a copy in your own national language with you, and also with the English official translation. I will have a look at the English because my Serbian isn't good or non-existent. And well, this treaty was created by UNCITRAL, which is a UN commission, a United Nations Commission for the development of the law in international trade. And it was based on two instruments that I will not really talk about them, but these two instruments were two conventions. One of them covered the formation of the international sale of goods, and the other cover the rights and obligations of the parties, and they are known as the ULIS and the ULFIS. They were created by a different organization that was The Hague, on the basis of a draft created by UNIDRA, but they were not very successful. However, the UN took on those two conventions and created the CISG, together with a group of experts coming from all over the world. Today, there are 97 contracting states, which makes it a very successful instrument just by the number of the countries who have considered this a useful treaty for commerce. The last of them is Saudi Arabia, that adopted at least the first two parts of the convention, and but basically we will see a bit later on in a map that most trading economies, important economies, are part of the CISG. And Professor was just saying that the CISG is very important in practice, but it's not only important in practice, it's also important as a model for legal reform in many jurisdictions that have modernized, updated their law of contracts and obligations on the basis of provisions or principles that we find in the CISG. So studying the CISG will also give you many good ideas for your own commercial law practice, I'm sure, or for your other exams. Those who have made the MOOT, you know that you acquire different skills that are very useful for not only the sale of goods issues, but also in general for commercial law. There are different databases that have been reporting on the case law applying the CISG in different jurisdictions, and in the screen you have some of them. On the screen is There is one by Pace University. There is one by the Unicitral itself called Cloud. And there is also one hosted by the University of Basel called CISG Online. And there is a lot of doctrine developed on the CISG, mainly in English, which is a very good thing, right? Because most people would understand the doctrine developed on the CISG on this language, but also in German. In German, the German scholars like Professor Schwenzer and many have also published in German, and you may have a look to those treaties as well. So this is the CISG map. It's not updated actually because I haven't found any so updated, but the countries that should be now in blue, who are not in blue, are Portugal. It's a small, probably you don't see it well, but Portugal is now a member state, and also Saudi Arabia, right? Probably a different. There is also a new African state. I don't remember, but probably yes. That map doesn't reflect that adoption. But by the numbers, it is estimated. This is just an estimation that if we take the figures of the World Trade Organization regarding what these countries represent for global trade, potentially the CISG potentially could cover around 80 to 90% of commercial sales in the world. In practice, we don't know really how many of those are covered by the CISG because we will see that there is a possibility to opt out, and in some circumstances, some sales goods will not be covered by the CISG, which are within those statistics from the WTO. The most important missings there that are not yet contracting states, you can see, probably you could help me, what are the countries that you see there that are important with regard to trade that are not in blue? Any guess? Yeah, UK. They have been resisting for, I don't know how to call that, for historical reasons or because some of legal protectionism, but they consider that they don't want to adopt the CISG because many sale of goods are traditionally also subject to English law, in particular for commodities. For commodities. But yes, you see UK, you see Ireland, you see India, probably the most important trading nations that are not part of the CISG, probably together with Malaysia, or Indonesia. Well, yes. So we will come back to this map in a moment. We will talk about the scope of application, and this is the first rule in the convention. I will say a few words about it because probably is the most important. And let's start with the first rule in Article 1.1a. You can have a look at your convention.
Edgardo,
yes.
While you're looking at the Article 1 of the convention, if I may interrupt just for a brief second, because I've been already asked, and I don't know in my, again, brief absence whether it was said, I hope you don't mind if questions come as you speak, because if you speak about something that's relevant for anyone in the room for a further clarification, I'm sure it wouldn't be a problem to raise the hand at that point in time.
Probably it's better. It's better that you interrupt me, otherwise I will get tired of listening to myself.
And just a short clarification on that point. If you wish to ask a question, please make sure you use the microphone, because we are recording this seminar, and even though we can all hear each other quite well, the recording will not have your voice if you don't use the microphone. So that's just a technical announcement. Sorry.
Very good. Very good. So yes, let's come back, and do not hesitate to raise your hands or just open the mic and send your question here. Excellent. So Article 1 tell us that the convention applies to international sale of goods. International is very important and is defined as any transaction between parties which have place of business in different countries, different states. So as soon as you have a sale of goods for example, that involves a Serbian seller with a French buyer, that would be two different states, that would be considered international. Actually, even if you have it with the UK, that would be considered international. So it applies to international transactions. It doesn't apply to domestic national sale of goods. For that, you have your own civil code, your own law of obligations, probably your own commercial code as well. So international, the sales should be international. But to apply a straightforward under Article 11A, it should be international and should also be between parties which are located in, I should go back, which have their places of business. This is a term, this is a concept important for the convention. Place of business in different contracting states. Okay? Not just states. Just states makes it international, but contracting states makes it to fall under the scope of the convention. And so you can start figuring out all those transactions where under Article 11A would fall under the convention. Imagine Mexican producer of tequila sending some bottles to, or several bottles to Serbia. That would be basically covered by the CISG, right? We will be very happy all with that sale. And you can also figure out like Brazil sending a commodity like sugar to another European country, or to Asia, which is covered, like for example China, that would be covered by the CISG because the two countries are in blue. However, if you have, for example, a sale between a company with place of business in New York selling something to a company located in London, in the UK, with place of business in London, that would not be covered by the convention under this provision, at least, because you have one contracting state, that of the seller, but the buyer is not located in a contracting state, so you cannot apply the CISG under Article 11A. You may be able to apply it under Article 11B, that I will explain now, but not under Article 11A. Okay, because you will have one party that is not located, that doesn't have their place of business in a contracting state. Okay. Now, Article 1B expands the scope of application of the convention to those scenarios where you have one party or two parties that does not have their place of business in a contracting state. And that will happen when, according to the rules of private international law, the law applicable is the law of a contracting state. So if we go back here, I mean, the clearest example would be the following. Oh, by the way, probably I should explain what private international rules means, right? Are you aware that many countries, European Union as a union has the best probably example, they have rules that tells you which law applies in a scenario where you have a foreign element. When you have two parties located in different states, that's already a foreign element, right? If the contract is to be performed abroad, it's a foreign element. When the contract is to be signed or was signed in a different place, that's a foreign element. What? Those rules tell us what law should apply when there are these foreign elements. It seems that as a matter of justice, judges should look at foreign law in certain scenarios when a foreign element is involved and apply the law that their private international law tells them to apply. So the convention is basically saying this. When the convention doesn't apply by 11A because there are not two contracting states, the convention could apply when, according to the rules of private international law, the law applicable is the law of a contracting state. So having said that, let's consider a contract between the US company as a seller and the UK company. If their contract says this contract will be governed, for example, by Swiss law, which wouldn't be impossible, that would be something feasible or probable. Switzerland is a contracting state, and so the CISG is part of Swiss law applicable to international sale of goods. That contract, in spite of the fact that the buyer is located in the UK, will be governed by the CISG under Article 11b, because we are applying Swiss law under the private international rules of the judge that gets to know that case. The judge actually could be somewhere, but the rules of private international law of this judge, in this case the law applicable to contracts, needs to tell him that the law applicable is one of a contracting state. And it's basically the same reasoning even if you have two non-contracting state parties, a seller and a buyer, that are not located in a contracting state. If the judge, who is knowing of the dispute, arrives to the conclusion that the law applicable is that law of a contracting state, the CISG will be applicable. Okay? For arbitral tribunals, it's a bit different. It's similar, but the arbitral tribunals do not apply the convention by Article 11a, because they are not judges in contracting states, but they have the rules of private international law, which basically tells them to apply the rules the law that they consider appropriate. And oftentimes, when there is two parties located in contracting states, they get to that conclusion as the CISG is an appropriate law for that, for those sales transactions, obviously, and also when there is not two parties from contracting states, arbitral tribunals will have a look at its own conflict of law rules and as well consider if the law of a contracting state is appropriate to govern the arbitration. Questions? Remarks? Frustrations? Concerns? Yes.
I have a question, which could also be a frustration at the same time. And I have to say that the idea came from my colleague, Stefan Jovanović, so we are trying to figure out how one of the issues plays out when it comes to the scope of application. And you will not come to it in the articles because none of the articles are there, but it's somewhat related to what you're telling now. What is a sale of goods? In the sense that when I mentioned that to Milena, she said, well, barters are covered. I said, not from what I read. She said, well, you read a long time ago. She always reminds me how old I am. Because the CISG apparently moved on and now barters are covered. And I ask that because of paying with crypto. If you pay with crypto, if you qualify it as an asset, then you have a barter. If you treat it as money, then you might qualify it as monetary payment, sale of goods. And I ask that because the issue comes out of the CISG. When you, for instance, go to a state court and the state court has to apply a law and goes through 11b, in order to apply its conflict of law rule, it has to qualify what does it have before it first, and choose the appropriate conflict of law rule. And we, for instance, have a different conflict of law rule for the contract of sale and a different conflict of law rule for the barter. So any thoughts on that? Because we do plan to write an article, so poaching your thoughts would be very welcome. Yes.
Yeah.
Before Edgardo answers, if I may, I would appreciate not to be quoted out of the context, and especially not to be misquoted, but we'll talk about that during the break. But I did say that you've read the CISG materials a very long time ago. Did not give you the final answer on your question. And yeah, I'm sure Edgardo is going to tell you that one of the questions you have raised is something that falls now within the scope of the CISG future work. It's a very pertinent question, but I'm looking forward to hear Edgardo's answer.
Well, I thought Milena was going to answer the difficult questions. Yeah, I think I'm gonna move to this thing to answer that. Okay, this is a diagram, and I want to use it to explain what is a CISG contract, and because this is important for the question, right? And so this diagram has a name. Louis Barrington, someone told me the name, but I don't remember the name. But what you see in the gray circle is what you can consider a CISG contract, and what falls upside this circle is not a CISG contract because it's not covered by the convention. Okay, and so actually we just talk about this. The convention covers what is within the circle, international contracts, right? So it should be international. What is upside the circle? National, right? National, great. And the second is basically related to the question. Remind me your name. Sorry, Vladimir of Vladimir. What is a sale? Because if you see this diagram, what falls into the circle is a sale. For the CISG to cover this, for this to be a CISG contract, needs to be a sale. And upside the circle, you have other contracts which are no sales. I'm going to talk about this in brief. But you have at least a sale, but he's making a good point. What is a sale? Do you find any definition on this in the CISG of what is a sale? There is no express definition, actually. And he already advanced that. He said you will not find a specific provision. But I think it's not that difficult to figure out what is a sale if you read through the 100 or even less, like 90 relevant articles of this convention. And it's difficult to it's easy to define sale as the exchange on the one side of goods against a price. Okay? But then you have to define goods, and then you have to define price. And most of the debates about software and digital assets, it's on the two concepts, whether it is goods, for example, any digital content, and whether you can pay the price with that type of money, if it is ever considered money, right? So the answer, it would take us probably the whole day. You see the discussions of the CISG Advisory Council on this topic. It take them not one day, it take them several months. Years. So regrettably, I don't have an answer, but this is I'm giving you like the coordinates, because the answer is within what you consider goods and what you consider what makes or what can you use to pay the price. Only money? Probably not. Probably you can pay with cryptocurrency, because nowadays it's commonly agreed that barter is possible. I mean, that the CISG covers barter, exchange of goods for goods. And probably you wonder whether this is relevant in international trade, right? Because this is more for the Mexican tribes in the south to exchange chicken for coffee, but it's very relevant apparently for some countries like China trading with other like continents like Africa, right? Or even with Mexico, China. And so also on the question of goods, it is nowadays also the majority view that software, digital content fits within the definition of goods. This was not the case at the beginning of the CISG, because I forgot to mention that the CISG was drafted on the 70s when there was something called telex and facsimile or something like facsimile. Like I was born in the 80s and I didn't saw a telex, for example. Probably came later on. Yes, so Ingeborg, Professor Schwenzer is going to talk about Article 7, which is very important to answer this question. So if you agree, I can move on. Yeah? Okay. So let's have a look at Article 3 and to our diagram. Article 3, it's about mixed contracts. And mixed contracts where you have a sale contract together in the same document with a service contract or a contract for goods to be manufactured, which is very, very common in many countries. Probably in Serbia, yes, because in Mexico it's very, very common. But let's start with 3 number 2. 3 number 2, yes, that mixed contract that involves services or labor. So it is not unusual that in international trade you have a sale transaction. There is the delivery of goods, but the seller also provides, agrees to furnish services or labor. So imagine, for example, the sale of laboratory equipment or medical equipment or even a machine. The machine is important, is the goods, but the machine is complex and and you need people to be trained about how to use the machine. And so the seller does not only provide the machine, but also provides the training or the installation of the machine. And those 2 obligations are not sales transactions. They are services or labor. And so the convention tells us in Article 3, in order for that mixed contract to get into the big CISG round circle, in the case of services, the services should not be or must not be the preponderant part of the obligations. In other words, if the sale is a preponderant part of the obligation, that contract will be governed by the CISG. But if the services and the labor is a preponderant part, is outside the scope of application of the CISG, you will not be able to use the CISG. You will use domestic law, national law, to govern that contract. Obviously, the question lies on what preponderant part means. Any ideas? Any ideas how we solve this question? It's there. You can just say what comes to your mind. I mean, it's in any case, it's not a fixed answer. So even people that have been studying this for many years, or courts that have the time to review this, they haven't actually come up with a really good answer.
Yeah, I could try. Yeah. I'd probably suppose that it's either going to be an economic criterion where we look at which part of the contract forms the main part of its value, rather whether the services are the part of the contract that's more valuable, or is it the goods. And the other possible criterion, I would think, is what makes the contract that type of contract, or what is essential to the contract. And if the sale of goods does not make sense without the services part, then we would deem it a services contract and thus not subject to the CISG, and vice versa.
Yeah, that's basically the answer. The answer better than what I could say. Yeah, either you take an economic approach and say, For example, 51% of the value is services, upside. This is oversimplifying, right? But 51% services is upside the scope of application. 50-50, well, apparently it is within because the preponderant part is not is not services. But if the services is 51% of the value of the contract, so well, it's upside. The problem is that most of the time you don't have a price in this contract, which are mixed. You don't have a divided price, by slots that tells you, oh, this is for services and this is for the goods. Usually you don't have that, and so you go to the alternative criteria. You try to figure out what is that contract in essence, right? And I mean, if for example, if let's coming back to software, if it is about the sale of software, and the software or it's goods, but what counts is the way you train the people from the buyer to use the software. What is important is that more than the software. Probably this is going to be outside the scope of application of the CISG. So there is no clear answer, and thanks God is not an article that you see often in litigation, or at least there are not many reported cases on this article. How what is my time? I am running out of time, right? I have 20 minutes only, or
20 minutes.
20 minutes. Yeah. Okay, so I'm gonna. The other part of Article 3.1, it's about when the buyer provides a substantial part of the material that the seller needs to finish the goods. So I give you the example in my country. In my country, it's they call it inbound or something like that in English, but basically. We receive many, the sellers in Mexico receive many of the materials from the buyer to assemble a TV, for example, an iPhone, or even to produce jeans. And these materials are provided by the big marks. Like, for example, if we go back to the jeans case, imagine Donna Cara or Levi's, or well, you know more about these brands, right? They provide the cotton, and they provide the labels, and they provide the buttons. And the Mexican is only actually assembling, making his labor, working on the assembly of these materials that were provided by the seller, because they come to Mexico, they are imported into a special regimes where they don't pay taxes, because the end goal is that the same materials are transformed and sold back to the buyer. And so for those contracts, the CISG will not apply when the seller provided what is, I'm sorry, I think I mistook the standard, the preponderant part of the materials, or no, the substantial part of the materials. The substantial part of the materials. And again, the question is, what is a substantial part? You go to economic criteria, or you go to what is the essence of the product sold. So you could imagine the jeans. If the buyer would only provide buttons and label, is that enough to take it out from the convention? Some of you would say no, because the seller is actually getting himself the cotton, he is designing it, he's making what is the essence of jeans, of pants. But some of you may say no, but what is important nowadays is the label, the buttons, because if it doesn't say Donna Cara or Chanel, is not the same pant, etc., etc. So it's the discussion, is the type of discussions you can have on Article 3.1. Any questions on this? No? Yes.
I think, Edgardo, it's the points that you raise are all very helpful to make us think about it, themes that we thought that we had known better. And I think that both in the case of whether the cryptocurrencies qualify as money or whether, the other types of goods, software is goods, or now in the case of what means substantial or what means preponderant in Article 3, it's very difficult to answer those questions unless one thinks about in terms of, who is the one to decide on these issues? And I know that this will be the subject matter of Professor Schwenzer on this issue, but can you give us just a glimpse of what would that mean when we have cases like this and a Serbian judge has to decide these questions? Whether can she or he resort to find a solution?
Yes, of course, yeah. I think he could have a look at Article 7, as Ingeborg will be explaining, to try to see if what these concepts mean. Obviously, you have to also try to see case law from the past, the materials we have on commentaries, on doctrine, on the CISG. But I know that there are a few cases or not cases or very few cases on this question. And I think that this means that in practice, usually you have two different contracts, or people would do different contracts, one for service, one for sale, or one for manufacture and one for sale. Or what often happens as well is that the companies don't sue each other because they are related companies. They are subsidiaries of the same company. The CISG will potentially apply because it doesn't matter who is the shareholder, the nationality of the shareholder. But we see few cases in practice. Yes, but basically you try to understand what these concepts means by looking into the principles that are in the convention itself. You never go outside the convention, as Professor Schwenzer will explain in brief. Good. Well, I already talked about a bit this, but if you have a look at Article 2, there are some type of goods that were excluded from the scope of application of the CISG. So it applies to goods unless they are mentioned in Article 2. And here we have an expert, Fanny, from your university, a former student, multi-finalist, who explored this article in depth because she needed to figure out whether drones qualify as aircraft, because if they qualify as aircraft, any sale of aircraft is excluded from the scope of the CISG. So again, you have different principles, rules of interpretations to see what the drafters of the convention meant when they say aircraft. Probably they didn't have in mind drones, especially not the small ones that we see now. Right? But also something important to mention about this article is that these are goods that they did not want to be covered by the convention for policy reasons. Either because they did not want to encourage international trade about them, because they saw them as something important for the state, or because they were already subject to a special regulations on this type of good. So, for example, we may say that electricity, aircrafts, ships were part of security, or at that time was part of something that was of national security. And probably they weren't sure if that should be trade, so with the favorite or simplified, because I would say uniform rules that offers the convention. So they excluded that. And then you have other things like the stock money that is also outside the convention, because most countries will have specific rules and limitations for the sale of stock, especially if it is public, and money. Otherwise, every type of good is covered by the convention, and you should not be thinking about goods as tangibles, because sometimes some country laws define goods as tangible. The convention uses goods in a commercial sense, and if you see the translations in other what is the translation in Serbian? How would you translate, as thing or as merchandise? What is the translation you have there? Because for me, as a Spanish speaker, and I also know French, they use the word merchandise. And this is more than tangibles. This is something you can trade. What is the word you use in Serbian? For goods. Roba. But what does that mean? Thing? Item, like, or it means like merchandise. So you could make the same argument in your own language. So anything that is merchantable doesn't need to be intangible or tangible. It can be a good under the convention. Questions? No?
If I may interrupt, we were just having our internal discussion here as a follow-up to the question posed by my colleague, Professor Pavić. And now, with the exceptions being mentioned from Article 2, let's note that the question he posed, whether you regard cryptocurrency as goods or money, also has an effect on the application of the CISG. Because if cryptocurrencies are treated as money, then their sale is excluded from the CISG. Whereas if we treat them as goods, then we might get into the question of potential applicability of the CISG, where cryptocurrency as goods is traded for money. But I mean, it seems to me more likely that that's not going to be the case.
My opinion, this is my personal opinion, like playing here, like we say it in Spanish, cascarita, like playing between friends, like a football match. If you use cryptocurrency as a means to pay the price, I don't see why it would be excluded from the convention. But if you want to buy cryptocurrency, that probably goes more into Article 2, which is money. It's not money. We know it's not money. But because countries do not consider it money, many countries at least. But it has a function of money. So if you want to buy cryptocurrency just as a subject matter of the sale, may be excluded. But if you want to pay with cryptocurrency, I don't see why you can use that as a means to pay.
And this might be a good introduction into what Professor Schwenzer will be talking later, because, when we ask the question, what is a cryptocurrency, are we going to rely on the national legislation that defines it, or are we going to apply the autonomous standard of interpretation that's provided in Article 701? But definitely these are some questions that will be tackled by the Advisory Council as well, and maybe in a year or two you might read a more elaborate opinion on this matter. I don't know whether there are any other questions in the room or comments.
Yes. Then just as a brief comment, if you deem a contract for the sale of goods paid by cryptocurrency as not excluded by the CISG, that already answers the question of whether buying cryptocurrency would be covered by the CISG. Because if you consider a sale of goods paid by cryptocurrency a sale of goods, then immediately you consider cryptocurrency a money, and that would be case law that you'd use sort of to say that it's not covered by the CISG later on.
Yes, but that was my consideration, that cryptocurrency could be assimilated to money. But as Milena mentioned, we should interpret what is money with the lens of the convention, not of national legislation. Yeah. Great, excellent. I was given too few time.
Just for extension.
What an extension. No, well, another thing in Article 2, Article 2 is it receives from the upside criticism because it looks like the convention is a Gruyere cheese because there are many things excluded. But the convention is only about the classical sale of goods. In other words, it doesn't cover judicial sales or auctions. So, and this is because the warranties, traditionally countries have different warranties for hidden defects and also rules on contract formation, which are different in case of auctions and judicial sales. So they decided, the delegates decided as a matter of public policy, that the convention should not, even if they were international, should not govern auctions and judicial sales. Okay, judicial sales is when the government is selling things that they had under, embargo or seize for different purposes. Excellent. The convention, what is within the cycle, covers both civil and commercial sales. And this is only relevant for those countries who still distinguishes between civil and commercial, mainly Latin American countries, but I don't know if this is the case here. Do you have a commercial code here with rules on sale or only a civil code with rules on sale? You have both or only one?
No, we have a law on obligations, but we currently don't have a code of sorts. Although our law on obligations essentially covers the relevant part.
Yeah. So for you, this, because if this is in Article 1.3, it says it covers both civil and commercial. But this is something they did for those countries who still have a commercial code with some provisions on sales and a civil code. It covers both. But what is important in today's reality is that according to Article 2.1, the convention does not govern consumers' transactions. Obviously, I'm simplifying the term, consumer transactions. In other words, if you have a look at Article 2, it says the convention does not apply to sales of goods, both for personal or family household use. So everything we buy in Amazon, even if it is international, if we buy it for our household or personal use, family or personal use, is not covered by the convention. It's not covered. That's covered by specific legislation protecting usually consumers in the domicile of the consumer, etc., depending on the rules of private international law. There is an exception to that. If the seller can invoke the application of the CISG in a consumer transaction when it was not apparent for him that he was entering into a consumer transaction, right? So, for example, if there is a person going from Mexico to the States, to the United States, and buys a whole a bus, a car, a very big car or a truck, he comes back to Mexico and he uses to transport his own family because he has a very big family. If it was not apparent for the seller in the United States that it was for personal use, the seller will be able to invoke the application of the convention. Okay, I have 1 minute to explain this. But I think Professor Schwenzer and others will also cover that. I'm putting too much in your plate, Professor Ingeborg, but it's because I have limited time. Validity. This is very important. Article 4 tells us that the convention applies to the formation of the contract, to the rights of obligation of the parties. It also applies to the interpretation of the contract, to the effects of the winding up of the contract. And it tells us, unless expressly provided for, it does not apply to issues of validity in the contract. So issues of validity has to be interpreted according to the CISG itself, not according to national law. But let me ask, What are issues of validity under your own domestic law? So we have a clear view what they are talking about. What questions in a contract raise issues of validity? How can you annul a contract, invalidate a contract? On which grounds in your own legislation, in your own country, civil law? What is it about? What is the elements for validity of a contract? Otherwise, I'm gonna call your law on obligations and have a serious talk to him. That I'm not, but you are shy. You're shy. For a contract, you need consent, right? That the existence of a contract, that's a matter covered by the convention, but you need free consent, right? So it needs to be free from consent biases. What are those biases usually in your own law?
Well, for example, they'd be fraud or making, I'm not sure about the word, but forcing someone into a contract, whether by physically forcing them to sign something or other types of...
Excellent.
That's good that you started with those, because those are clearly outside the convention. Fraud and force or violence, right? Yeah. Whether mistake, which is another type of vice, is outside the convention, is disputable. And now the council is writing an opinion on that. Apparently, most type of mistake will be covered by certain provisions of the convention that tells you how to interpret the conduct or the statements of a party and what to expect from certain statements with regards to conformity of the goods. But that's basically it. The convention do not have provisions on illegality of contracts, or doesn't have provision on fraud, doesn't have provisions on violence, gross disparity, and this will not be covered by the convention. This doesn't mean that the convention will not apply, will apply. But together with the convention, if there is any claim of invalidity relating to this, you will need a different law to solve those issues. And it's the same with regards to what are the effects on property. The convention tells us that the seller is obliged to transfer the property of the goods. But the convention doesn't have provisions on when property passes from the seller to the buyer, and whether you can sell, for example, property that belongs to other. Those issues are covered by a different law that must be determined by the judge or the arbitrator. And that's basically what Article 4 tells us. Other issues that usually fall into a validity scenario in most countries, like formal validity, is covered by the convention. Okay? And mistake, there are many provisions that could also apply to alleged mistakes. But okay, 3 minutes late, and I finished only with Article 6. No, 3 minutes not left. 3 minutes past. 4 minutes. Saying that the convention has the principle of freedom of contract in Article 6, which means that the party can tailor-make their contract as they wish, which also means that they can derogate the convention completely, exclude it, or certain provisions of the convention they can also derogate from them by agreeing in certain contract clauses to solve those issues in the convention. So thank you very much. And I'm happy to take one question only, because we are, right? Or I pass the questions to Professor Schwenzer as well.
Do we have any additional questions for Edgardo? Oh, this was easy.
It was easy, right?
Thank you very much, Edgardo.
You can pass me my bottle. Yeah.
we gradually move through the convention and we have arrived to Article 7. It is an absolute joy for every moderator to have Professor Ingeborg Schwenzer on the panel, and that is for at least 3 reasons. The first one is that she doesn't need any special introduction. Everyone who has ever read anything on the CISG is already familiar with at least one part of her work. Second, she feels more than comfortable speaking about any topic of the CISG, so the moderator does not have to steer the discussion. And finally, and perhaps most importantly, even though she is the brightest star of the CISG universe, she doesn't act like a stereotypical star. She is very approachable, very kind, so the moderator does not have to invite and encourage questions. So prepare to take lots of notes, because over the next hour or so, you will learn a lot about the interpretation and gap filling under the CISG. Professor Schwenzer, the floor is yours.
Thank you very much, Marko, for this very kind introduction. Ladies and gentlemen, let me first of all thank you, my dearest friend, Professor Milena Jovanović, for bringing us again to Belgrade, especially bringing me again to Belgrade. The last time was 2.5 years ago when I attended the Belgrade pre-mood here, and for bringing the CISG Advisory Council. Actually, you might not know it, Professor Jovanović is our General Secretary in the CISG Advisory Council and thus is managing the whole council, for which I want to thank her here again. So thank you very much, and also for organizing this wonderful conference. Ladies and gentlemen, I'll talk about interpretation and gap filling. Before I start, just a short question, because it's going to be important for my presentation. Do we have this year's mood team among us? Okay, 1, 2, 3. More? Oh, the whole row. Okay, I heard you are 7 on this on the team. Okay, so I might just go a bit in the direction of this year's problem when we discuss Article 7. So, and please feel free, all of you, to ask any questions regarding my presentation. Interrupt me. I'm happy to take any questions. So now I have a problem. I have to get my presentation.
Okay, so
Do I have to?
let me see where it is.
No.
Interpretation gap filling. Here it is. Okay. And you can use the remote control to move through the slides.
Ah, wonderful. Okay, you have the CISG in front of you. I'm happy, and I ask you, I don't bring up the articles, the wording of the articles on my slides, so please read them while we go through them. So, in Article 7, Article 7.1, we have rules for interpretation of the convention. Actually, Article 7.1 has been the blueprint for all later conventions. So in all later UNCITRAL conventions, UN conventions dealing with international commercial law, you will find this rule on interpretation. Article 7, Para 2 gives us rules for gap filling. We will discuss how we can distinguish, or whether we can distinguish, interpretation of the convention and gap filling under the convention. The aim of both Article 7, Para 1 and 7, Para 2 is a uniform interpretation and application of the CISG. I mean, it was hard enough to come to the CISG as a uniform law on sales, on contracts for the sale of goods. So if we do not strive for uniform application and interpretation, this uniformity will be done within a very, very short time. We had the experience, actually, there were conventions on checks and drafts, which were uniform conventions, and nobody remembered it. So after some decades, nobody saw that these conventions were uniform. They were interpreted differently in the different member states. So uniformity was gone. So that is why it is very, very important to keep in mind that we have to strive for uniform application and interpretation of the convention. Article 7 tells us about the interpretation of the convention. Yeah, it doesn't tell us, and that is also already now important for our Wismutis of this year. It doesn't tell us about the interpretation of the contract. Yeah, and that is important because in Article 7, I will mention it, we have a mentioning of good faith. We have it in Article 7 for the interpretation of the convention, but we do not have it in the provision relating to the interpretation of the contract, which is Article 8 and also Article 9. So we have to clearly distinguish between the interpretation of the convention and the interpretation of the contract on the other side. So let's start with the interpretation of the CISG with Article 7. Please take Article 7 and have a look at it. It reads, in the interpretation of this convention, regard is to be had to its international character and to the need to promote uniformity in its application and the observance of good faith in international trade. So the first point we have to address is the international character of the convention. And Professor Jovanović already mentioned it. That means that the CISG requires an autonomous interpretation. Yeah, autonomous interpretation means that we have to interpret the convention out of itself, autonomously. We are not allowed to rely on any terminology that might be similar to the convention found in a domestic law. For example, US American courts very often get it wrong. They find a term in the CISG that resembles, for example, to the Uniform Commercial Code. I mean, both are in English, so it's easy that a term might resemble to a domestic law in an English-speaking country. And then they come to the conclusion, oh, the CISG is similar to the Uniform Commercial Code. Oh, then we rely on all the case law that we can find interpreting the Uniform Commercial Code. This is definitely wrong. And the CISG drafters tried not to fall into this trap, and when forming the terminology under the CISG, in many instances, they explicitly deviated from terminology that was used in domestic legal systems. I'll give you one example, that is the term avoidance. Avoidance for breach of contract. This is the term used by the CISG, whereas in English-speaking countries, avoidance or the bringing to an end of a contract due to a breach of contract, that would be the concept, the general concept. Avoidance is in English terminology in England and also in the United States, and I think also in Australia, we speak about termination, not avoidance. And the CISG drafters were aware of this problem, and they explicitly invented a new term, avoidance, in order to make it clear that you should not fall back on the term or on the concept of termination that is used in common law countries. So this is one example for autonomous interpretation. Edgardo also mentioned a very, very important sphere of application of this principle, and that is Article 4. Article 4 that excludes validity questions from the scope of application of the CISG. And the question, what is validity, has to be answered out of the CISG without having regard to any domestic approaches. Edgardo already mentioned the questions of mistake. Mistake is a concept that is so differently dealt with in domestic legal systems that if we were to allow mistake under any domestic legal system to be applied alongside the CISG, uniformity would be totally gone. Because I give you an example. In civil law legal systems, mistake is very generously granted, and a party may rely that it was mistaken as to some features of the goods and may rescind the contract relying on such a mistake. In common law countries, mistake is very narrow and is not narrowly granted as a means to undo the contract. So if we were to apply, let's say, a buyer to rely on domestic concepts of mistake because the goods did not have the features that it expected at the time of the conclusion of the contract, and a buyer in a common law legal system would not be able to do that, then uniformity would be gone. Yeah, and what we want is uniformity in that case under Article 35, so that a buyer in a civil law country and a buyer in a common law country may have the remedies under the CISG under the same circumstances and not under different circumstances depending upon the domestic law of mistake. Another example, I don't know whether that did Serbia revise its law of obligations recently with regard to the CISG? No. So you still have the old civil law concept.
We have a 1978 law of obligations, which is to some extent similar to the Swiss Code of Obligations.
Okay.
So it's more modern than the civil code we had back in the
If it's close to the Swiss law of obligations, then you probably have a provision that a contract which performance is not possible at the time of the conclusion of the contract is void ab initio. You still have that antiquated concept, huh? It's a Latin concept. It stems from Roman law, yeah? And Roman law was dealing with the sale of cattle and the sale of slaves, yeah? And all the consequences in the sale of goods are based on this concept. So you ask yourself, why do we have that? Well, naturally, if the slave is dead or if the cattle is dead at the time of the conclusion of the contract, well, the contract cannot be performed. That we have initial impossibility leads to the contract being void ab initio. Very antiquated concept that is done with a way by the CISG. I don't tell you why. We can deduce this from certain articles of the CISG. Anyway, the CISG deals with initial impossibility in the same way as it deals with consecutive impossibility after the conclusion of the contract. So you have the same remedies. It doesn't matter whether the ship sank 1 minute before the conclusion of the contract or 1 minute after the conclusion of the contract, which is in most cases not possible to be evaluated after that. So it makes perfect sense to treat initial impossibility in the same way than subsequent impossibility. And that means that is not a validity question under the CISG. Understand? Yeah? Because the CISG treats a contract that is initially impossible as being valid. So it would undermine uniformity if we were to go to a domestic legal system that allows invalidity for initial impossibility. So those, I could bring you many more examples under Article 4, where we need the autonomous interpretation of the CISG. The second point that we find under Article 7, the second guidance we get, the first one is international character. The second one, we must strive for a uniform application. We must have a look to the need to promote uniformity in its application and interpretation. Well, and this is a difficult question. How can we come to a uniform application and interpretation of the CISG? In domestic legal systems, this is easy. Yeah, you have the structure, the level of different courts, and you have a highest court who decides which lower court is right or wrong. So you have uniformity in your domestic legal systems if you look to the case law of your Supreme Court, of your highest court. We don't have that for the CISG. There is no international court on commercial matters. There are international courts, you know about that in The Hague, but we don't have that regarding private law issues. We have no court of last resort. This is also different, for example, in the European Union. In the European Union, you also have a highest court, a European court, to decide disputed questions among the EU members. You also have a highest court in a similar structure that is called OHADA. It's the organization of African states organization to unify business law in African states. So that has been perceived to be a lacuna of the CISG, that we do not have a highest court, a court of last resort, to decide disputed questions under the CISG. Well, I think it's not only a lacuna, maybe it's not that bad, because in the European, you talk about the Luxembourg torpedo. What does this mean? A party not prevailing in domestic courts might go to Luxembourg, takes years, and litigate the case there, and then come back with a decision. So the whole process from the first instance in a member state of the EU, with going up to the Luxembourg court, to the European court, then going back to the domestic courts, that may easily take 8-10 years. So is that advisable under the CISG? I think it also has good sides that we don't have such a court of last resort. But then, how can we achieve uniformity? Well, the first institution to secure uniformity is UNCITRAL itself. UNCITRAL, United Nations Commission on International Trade Law, that was already mentioned by my dear friend Edgardo. So UNCITRAL has several instruments to help us to secure uniformity. One, for example, is the UNCITRAL Digest, freely accessible on the internet, by the way. There are many instruments that you can freely access via the internet, which make it very, very important because, I mean, we have member states where we have students and students' team. I was just doing a capacity building program in Nepal, where students don't have that resources that we have in Western countries, you know. So I work with them, and we work with the case when the case comes out, actually, and we work with the internet, and we look what can we get from the internet to solve the case. And there are many possibilities, and one is UNCITRAL itself, and we have the UNCITRAL Digest already in its second edition, which is kind of a commentary, gathering case law from all member states of the CISG and bringing it together in kind of a commentary under the relevant articles. Furthermore, we have Cloud, that is case law on UNCITRAL texts. That is a database, and it gathers case law from all member states of the CISG. And the system is, in each member state, we have a rapporteur who reports case law from its state to UNCITRAL with an abstract, an English abstract, and this English abstract at UNCITRAL is translated into the 6 UN languages, which are English, French, Spanish, Russian, Chinese, and Arabic. So you have the abstract in all the 6 languages of the UN, and then you can go to the full text in the original language. And it's not that difficult anymore. I mean, if you find a German case, nowadays we have all these machine translation possibilities. I mean, you just type it into
The translator?
The
translator.
No, Google. I don't use chat. Also, chat. What do I use all the time? DeepL. DeepL.com. You type it into DeepL, and then you get the translation. At least you get it. Probably, I don't know whether DeepL features Serbian. Probably not, but you get it in English or French or Spanish. Okay, so that is how you can work with Cloud. And the problem for UNCITRAL is that UNCITRAL has to stay neutral. I mean, it's a UN commission, so they are not in a position to criticize member states. So even if the commentator in the UNCITRAL Digest finds that U.S. courts get it wrong, or that the German Supreme Court gets it wrong when applying good faith to the behavior of the parties, then this rapporteur would not be allowed to state that in the digest, because UNCITRAL has to stay neutral. And against this background, actually, the CISG Advisory Council was founded by Al Kritzer, who also, during his lifetime, paid for our meetings, paid for our airfare, paid for our accommodation when we met. So he found the CISG Advisory Council, composed of now, Milena, 15 members?
12 members.
12 members? Okay, so.
And several emeritus members.
Yeah, 12 active members and several emeriti member. We are all professors dedicated to the CISG, but also knowledgeable not only in our own domestic contract law, but coming from a comparative background. So knowing also civil lawyers, knowing common law, and vice versa. So that is our background, and we are discussing questions that we find that have to be discussed because there are differing views in domestic case law applying the CISG, or because there are questions coming up and urgently needing discussion, like now the CISG in the digital world. because, as Edgardo said, the CISG was drafted in the 1970s, and in 1980 nobody thought about the internet. And when software was discussed in the 90s, it was cute, I would say. They said, oh, if software is on a disk, then it is the CISG applies, but if it is not on a disk, then the CISG does not apply. Everybody today just frowns and would never subscribe to this old-fashioned definition anymore. So the CISG Advisory Council had issued how many opinions now?
Over 20.
Over 20, yeah. I think we have 22 or so, 22 or maybe even 23. And, well, certainly these opinions are not binding, yeah? But what they have been cited by many courts, even by many Supreme Courts, including the German Supreme Court, the Netherlands Supreme Court, the Hoge Rat, but they have also been cited by American courts as so-called persuasive authority. And in arbitration, I'm sitting in many arbitrations, wherever a party can rely on a CISG AC opinion, they do it, yeah? And it is professional, you're acting professionally if you're using any and all sources. I talk now to the current Wismut team. You have to use all sources to support the position of your client. And one of the primary sources of interpretation of the CISG before you turn to domestic case law and before you turn to scholarly writing would be an opinion by the CISG Advisory Council. Okay, so that is something to rely upon and to achieve uniformity in interpretation. Then we have precedents interpreting the CISG. Edgardo already mentioned the CISG databases that we have. Unfortunately, one that also contained translations of other languages has been discontinued in 2015, so it's no longer of any value. That is the PACE database. So what I would really recommend to you is CISG Online, which is the most comprehensive database, and the big benefit you have from CISG Online, you can search via article. Yeah, and then, for example, it gives you a Dutch decision that cites this article as main article, mostly discussed article in the case, and then you can search via you can search the document. It's a PDF document. You search it, and then you come to the paragraph discussing this provision, and then you can take this provision and put it into DEPO. Yeah, and then this paragraph, and then you have you know what the Dutch Supreme Court, for example, said. So it's very easy today if you use the internet, and every council is now supposed to use the internet. Arbitrators are used to use the internet, certainly. What is still a problem are domestic judges, because many domestic judges even don't speak English, yeah? Especially like, for example, domestic judges in Germany. They would never make an internet research. Are also domestic judges, for example, in Brazil, yeah, or in Japan, let alone Japan, yeah. Nobody speaks English there, and the Wismutis do have biggest problems to participate in the Wismut because they do not speak English. Yeah, so a Japanese judge would never ever go to the internet and do its own research. So, and then we come to the last point, and I have worked a lot on that, and that are commentaries. I mean, commentaries are usually in English. I also have a commentary in English, but what I did is I pushed hard for this commentary to being translated to other languages. And the first one was my dear friend Edgardo, who translated it with a team of scholars, translated it to Spanish, and the Spanish version is already in its second edition. But we do have many other versions. We have a Portuguese version. So the Brazilian judge will take the Portuguese version of the commentary, which is identical with the English version, which the English-speaking council will use to plead in front of the Brazilian judge, or at least instruct the Brazilian council to go in front of the Brazilian courts. And in March, actually, I will have to fly there. We will have a Japanese version of the commentary. We have Polish, we have others. I don't know. We have Turkish version. I don't know all the versions. I don't have them in my mind. So these and that was my aim, to reach judges who do not speak English and therefore never would use my English commentary, and to give them a commentary in their own language in order to be able to interpret the CISG in a uniform manner. And finally, we have scholarly writing that you also always find, or much of it you find on the internet. Every moot court session, I get requests whether I can send my articles are referring to the specific problem, and I always answer them. Go to my website. They are freely downloadable there. So I breach the rights of my publishers by immediately publishing my articles on my website for free download for all the students in the world. Okay. Interpretation of the CISG, and now we come to the third point. Marko, how much time do I have?
See? Around half an hour.
Half an hour. Okay, that's good. Okay, we come to the third point, and that is especially interesting for our mooties of this year. Article 7.1 tells us to observe or to have regard to the observance of good faith in international trade. Well, the principle of good faith is a cornerstone of civil law countries, but it is not accepted in common law countries. There is a provision in the Uniform Commercial Code mentioning good faith, but it's not at all interpreted in the same way as in civil law countries. In Australia, there has also been a discussion about good faith, but still, it's not a principle that is followed like in civil law countries, because in civil law countries, it's not a principle to interpret the statutes, the civil code or the code of obligations, but it's a principle to interpret the contract. It is also a standard for the behavior of the parties. And especially, it's a principle under which you can develop duties of the parties, like, for example, information duties that are neither contained in the contract nor contained in the statute that you apply. So you can imagine those, like in many other spheres of the convention, we have two poles coming together, civil law and common law. And they they collided in the conference on the CISG. So there was much dispute about the principle of good faith, and delegates from common law countries said, we will never accept good faith as a principle for the standard of the behavior of the parties, of interpretation of the contract. So the least compromise one could find was to put it into Article 7 and to confine it to the interpretation of the convention. Still, there are some scholars, and not only scholars, there are also some courts, even Supreme Courts in countries that are saying, well, good faith is a general principle of the CISG, which I wouldn't underwrite, But, I mean, if you want to develop duties from good faith, probably you have to rely on these voices that say good faith is a general principle of the CISG, not only a principle to interpret the convention. Once you are arguing for the other side, you have to rely strictly on the voices that say no. It was disputed at the Vienna conference, and it was never accepted that this be a general principle under the convention. This distinguishes.
Can I interrupt you to pose a question?
Oh, sure.
Yeah. So I just wanted to ask you, what was their reasoning? Why didn't they want to accept that as a general principle? Like, is it too...
Because the CISG is a compromise between common law and civil law, and it was totally unacceptable for common law lawyers to have good faith as a general principle, because, there is a basic difference between civil law and common law. And I think that is why common law is more fit to adapt to the needs of international parties. What international parties need is predictability. They don't need fairness, they need predictability. And if you introduce such vague terms like good faith, that makes the outcome of a case unpredictable. And that's not what international parties need. Whereas the civil law countries seem to tend more to fairness of the outcome. The worst example is Brazil. Everything is based on boa fé. And you can develop anything. You can develop wonderful pre-contractual duties just from boa fé. But I mean, this makes the outcome of a case entirely unpredictable. And that's also it's not only that the common law lawyers would never agree to a general principle of good faith, and that would have made it impossible for the CISG to be accepted in common law countries. We wouldn't have a worldwide coverage. And we already, although we miss the United Kingdom, we have many common law countries who are member states of the CISG: Australia, New Zealand, Singapore, many other, Canada, US, all these are very important common law countries. They would not have accepted the CISG with a general principle of good faith. And I think it's better not to have good faith in the CISG, because the outcome becomes more unpredictable if you have vague principles like the principle of good faith. Okay.
That point, Professor Schwenzer, that's very interesting, the point of unpredictability that good faith brings up, especially not having an international court that can have the final word on that. But let me ask you this question. I've seen many commentaries speaking in favor of reasonableness being all over the convention. Reasonableness, to me, also brings up this issue of uncertainty. What do you have to say about that point?
Yeah. You're perfectly right. And I have to admit, and now we come to our this year's Moody's. Yeah. Although, I mean, in civil law jurisdiction, duties are developed from the principle of good faith. If you turn to common law, some of these duties might be derived from the contract. Yeah, you might have implied terms in the contract. Yeah, and I think this year's Moody's are well advised to look into the contract and into the behavior of the parties, prior behavior of the parties, maybe to develop duties from there. Yeah. So the outcome, as in most cases, also I could give you, I don't know, 100 examples where we have different poles that we start from in civil law countries and in common law countries, but in practice, we are moving together, and the outcome of a case very often is not different. If we, for example, develop a duty of information from good faith, or if we develop it from the contract and from the prior behavior of the parties. So the outcome is very often very close, because what is just is usually perceived in the same way. But the starting point is different, and that is important. Alejandro, you're perfectly right. I mean, reasonableness is also very vague, and so it also may make the outcome unpredictable. Okay. Methods of interpretation. First, and that is something you really never forget. First, also when we interpret the CISG, we have to start with the contract. Yeah? For example, last year's Wismut problem, the question of drones. So the question was, how did the parties perceive drones? Did they perceive them as aircrafts or as non-aircrafts? So you look at the contract, and if the parties wanted, even if you were to decide that drones are an aircraft, if the parties wanted to apply the CISG, then the CISG applies. Yeah, although under Article 2E, aircrafts are excluded from the application of the CISG. So first thing, also when you interpret even the convention, you look at the contract, and that again applies to your problem. How do we develop a duty of information? You first look at the contract. Okay. So when we interpret the CISG, like interpreting any international or domestic statute, we look at the wording and at the systematic position. So this is a general approach to interpret a statute. Beside the wording of a certain provision and its systematic position, we might also look at the preamble. Don't forget the preamble, because there are interesting things mentioned in the preamble. For example, in para 3, being of the opinion that the adoption of uniform rules which govern contracts for the international sale of goods and take into account the different social, economic, and legal systems would contribute to the removal of legal barriers in international trade and promote the development of international trade. So the CISG was well aware that we have different developments of country, that we have the so-called developed country, the transitioning countries, and the developing countries. And we can take this into account when interpreting the convention. I'll give you one example. I have authored the comments on Article 38 and 39, the duty to examine the goods and to give notice of any non-conformity by the buyer to the seller. Well, there are different understandings of that, and there are different possibilities of a buyer, for example, to examine the goods, whether it is situated in Cameroon, which is now a member state of the CISG, or whether it is situated in Germany, with access to all possibilities and with the knowledge in the background under German law that you have immediately that you have to immediately examine the goods and immediately give notice within 3 or 5 working days under domestic German law, not under the CISG. So in interpreting Article 38 and 39, I have to take these social differences and locations and usages at the place of the buyer into account. This is my conviction. And that also makes the CISG a fair contract law, adjusting to the interests of all sellers and buyers, also of sellers and buyers in developing countries, and making it possible for them to take part in international trade. So I think the preamble should not be forgotten when we interpret the CISG, because there is such a principle of fairness also regarding the global south nowadays, which is an important question, I think. What we have to mention wording, what makes it difficult, that the CISG has been drawn up in 6 authentic languages, namely the languages of the UN. I already mentioned English, French, Spanish, Russian, Chinese, Arabic. So the problem is all of these 6 languages are authentic. So nothing prevails over the other. The problem is that we have different wording in the different languages. And that, well, mostly the 3 first languages, English, French, and Spanish, are more or less the same, but we have huge discrepancies in the 3 other languages. For example, last year's problem, I don't know whether, Fanny, you came across it. You did. The Russian version of the CISG was clearer in some direction regarding aircraft. What was the Russian version?
Аеротранспорт, воздушный аеротранспорт.
So means for transport, yeah? Which is different from aircraft. So one party could rely on this Russian version, and then you have to decide what do we do if we have differing versions of the authentic versions of the CISG. Is there one version? Well, usually English was the mostly used language during the conference. There were some subcommissions that discussed in French. So usually you would say, well, probably English prevails. But if you had, for example, a Serbian party and a Russian party, well, you might say, well, maybe both parties relied on the Serbian version. What does it use for aircraft?
Воздухоплов.
Is it the same like Russian?
It's more similar to the English.
It's more similar to English. Okay, so if it were to be more similar to Russian, you could say, well, the parties obviously probably thought more of the Russian version than of the English version. Yeah, but what is also very important, that besides these 6 authentic versions in the authentic languages of the CISG, no other version of the CISG is relevant. Yeah? Neither the German version that has been agreed between Germany, Austria, and Switzerland, nor the French, nor the Japanese version, nor the Serbian version. Yeah, all these are non-authentic translations of the CISG. Yeah, and you cannot rely on them. You have to rely on one of the UN language versions.
Finally, just add something for the benefit of our guests and our students with respect to the Serbian version, which is, as usually is the case, published as the law on ratification of an international convention. And the text, we have noted in our writings, all of us who deal with the CISG, suffers from several problems in terms of translation and understanding of the terms used in the English or any other text. And it has already caused problems in practice, luckily in one instance, to the best of my knowledge, on interpretation of Article 39, which in Serbian version stipulates that the buyer has to send notice of nonconformity, whereas in English it's give notice of nonconformity, and one arbitral tribunal was keen on interpreting the wording as sending in terms of, written form, it needs to be complied for the notice, and oral notice does not suffice. Whereas under every other interpretation of the same provision, including the general principles or no form requirement, one would reach a completely different conclusion.
Just to add, when we ratify the convention, when we discuss that. So the translation is there for the benefit of people sort of understanding perhaps what is there, but I think that doesn't dispense of the need of the judge to inquire into the real text of convention. Otherwise, it fragments into, so to say, barbaric translations like Latin fragmented into many languages. So, but the problem is there, and I would say it's accurate. No translation is perfect.
Yeah, and I would be surprised if Serbian judges look at the official languages of the CISG. Instead, they look at the law on ratification of the CISG in Serbian language, and they cannot be aware that there is a problem with translation unless they have, come to this seminar or have attended our classes in international commercial law, which are not mandatory, by the way.
Maybe we should have a Serbian version of the commentary.
We were just discussing this.
But I remember what Milena says. I mean, someone picked up the phone and says, we have a problem with that. And they said, well, it says give. It said send, sorry. So it has to be sent.
Yeah. Yeah. I thank you very much for this intervention, because it really shows how problematic it is if judges do not consider the original, the authentic versions of the CISG, but instead rely on their national translation, which is not relevant. Yeah. Okay. Travaux préparatoires. Well, that has been a while now, 50 years, that they were working on the convention, and so it's a bit old, and it's getting less and less important, like, for example, as the world moves on, like, for example, with regard to digital issues. Relying on the travaux préparatoires would be entirely useless. It has been discussed methods of public international law. There is a Vienna Convention, not the CISG Convention. There is a Vienna Convention on treaties of 1969, how to interpret international treaties. Well, this relates to the states who are members of these treaties mostly, and besides that, the principle espoused in this convention, they are so vague that that they are not very helpful for interpreting the CISG. One of my favorite methods to interpret the CISG is comparative law. And that in three different regards. Well, the first one is when interpreting the CISG, we have to look at all case law in all CISG member states. Yeah, and we should not be like, again, American courts, especially the New York court. I don't know which circuit is it, but doesn't matter. To the very day, it has a template that it always copies into a CISG decision. Up to now, there has been very little case law on the CISG, despite there being 3,000 or 4,000 cases out there in the internet. And then they are citing only not even case law from other circuit courts or district courts in the United States. They are only citing their own case law. So that is certainly not what one should do. But also, I mean, other courts, like if you look into a case decided by the German Supreme Court, look into the footnotes. It's mostly only Supreme Court decisions from Germany. It is German scholarly writing, nothing else. Yeah, and that is why, the problem is, they have the commentary in German, but judges now are not using books anymore. Yeah, they don't have the money to have libraries and books. They have databases. And it is decisive, for example, what Beck Publishing House puts into the Beck databases that goes onto the desk of the German justices. Yeah? And if they don't have an English commentary in there, they have only German literature and German commentaries. And so they use only that. And they don't have the time nor the knowledge to use the internet, actually. They just use the databases that is provided by the government. So this is problematic, and it's done. But at least if you are a scholar, then you have to consider case law from all member states, which is possible via the databases. You have the international databases. The second point how I use comparative law is when I look at the origin of a rule, yeah, and at the discussion of a rule. So, for example, I talked already about Article 38 and 39, examination and notice requirement. So this was initiated or brought in especially by delegations from civil law countries, especially from countries that have been very much influenced by German law. That in German law, in the German Supreme Court, German law knows such a very strict notice requirement in their commercial court, and it is very strictly applied by the Supreme Court, namely that immediate notice has to be given, which means within 3 to 5 working days after the buyer received the goods. Imagine, yeah? And that is strictly applied, even if the goods arrived 1 day or 2 days before Christmas Eve, then the buyer has to give notice between Christmas and New Year's Eve if there is any non-conformity. You can imagine. That is a booby trap for all buyers, yeah? And so it was these delegations who insisted on a duty to examine and give notice. And there were other delegations in many, many countries, especially in common law countries. There's no such duty. Yeah, in countries very much influenced by French law, there's no such duty, or a duty that is interpreted in a different way. So when interpreting Article 38 and 39, I have to take all this into account, yeah? And not just like the German Supreme Court did in its first decisions on Article 38 and 39. They just took their decisions on Article 37.7 of the Commercial Code and transposed them to the CISG. Yeah. So I sat there when authoring for the first time these articles, and I thought, oh gee, what am I going to do? I need uniformity, so I have to find a solution that on the one hand is acceptable for especially common law lawyers who don't know about such a duty, and on the other hand, for the German Supreme Court, who is so strict. So I thought, okay, what would be acceptable to both? And then I came up with what was later called by a colleague of ours, now teaching in Australia, Camilla Barsch Andersen, the so-called Noble Month. I said, if there are no other indications calling for a shorter period, then the buyer has 1 month after discovering the nonconformity to give notice of the nonconformity to the seller. And German Supreme Court accepted my suggestion. So Swiss Supreme Court also, and there are French courts applying this Noble Month. So I'm quite happy to have helped a bit to a uniform interpretation of these provisions. Then my third point, how I want comparative law to apply to interpret the CISG, is that we have to follow domestic legal developments. For example, for many years there has been a discussion in domestic contract laws whether you can, if there no loss has been established after a breach of contract, whether you can have a disgorgement of profits if the contract breacher made profit out of its breach. And when I first heard about this discussion, which goes back to a very famous English case, where the then still House of Lords said, breach of contract must not pay. So even if there has not been a loss on the part of the aggrieved party, I can still take away the gain that the contract breacher made out of the contract and give it to the aggrieved party. So that induced me at least to advocate under Article 74 the possibility of calculate a loss on the gain made by the contract breacher, so-called gain-based damages. So that would be, and what was my motivation behind this? It was, if I leave this question to be decided by domestic law and not bring it under the CISG, then again, for these cases, uniformity is gone. Yeah, and I want to embrace new developments and bring them under the CISG. I want to embrace cryptocurrencies and all that, and bring them under the CISG in order that the CISG will not in 20 years be outdated and nobody will apply it. Oh, come on, this old thing there. No, we have to develop it and we have to embrace new developments. In fact, like cryptocurrencies, and in law, like, for example, questions like disgorgement of profits. Last 5 to 10 minutes. Woo!
Time flies.
Use of uniform project. That's also for our mooties. Yeah, because I already mentioned. Did I mention it? Yeah. There is a basic difference between the CISG and the UNIDROIT principles. The UNIDROIT principles are very civil lawish. Unfortunately, there were hardly any common law lawyers, or there are hardly any common law lawyers at UNIDROIT, and thus the UNIDROIT principles also have been very much influenced by German lawyers, by German scholars, and by French scholars. So they are too civil lawish to be ever accepted by a common law lawyer. And one of the points is that unlike the CISG that mentions good faith only for the interpretation of the convention, the UNIDROIT principles have an explicit provision on good faith. Good faith in the sense of civil law as a standard for the parties, as a standard for interpretation of the contract, as a standard also to develop duties. Okay, and now the question is, can we use these uniform projects, especially the UNIDROIT principles, to interpret the CISG, or I move forward to fill perceived gaps in the CISG? Because I say perceived gaps, if you can develop something out of the CISG, and be it the result that the CISG does not have a duty to inform, then there's no gap, then you cannot go to somewhere else and fill a perceived gap. So the question is, can we use the UNIDROIT principles to interpret the CISG or to fill any perceived gaps? And this is very much disputed. People who are very much favorable of the UNIDROIT principles say yes. In their preamble, the UNIDROIT principles themselves state that they want to be applied to interpret international conventions. They wanted the UNIDROIT principles to be applied to interpret the CISG. Well, I think it doesn't matter whether the UNIDROIT principles want to be applied to interpret the CISG. It's the question whether the CISG accepts this interpretation by the UNIDROIT principles. Well, there are formal reasons why not to apply the UNIDROIT principles. One is a temporal reason. They came later than the CISG. How could they be applied to interpret the CISG? I think the main reason are the differences. And if you have such a point like the CISG does not accept the general principle of good faith, you cannot bring in good faith via relying on the UNIDROIT principles. That is against the uniform interpretation of the convention. Or there are other examples. For example, you have strict liability under the CISG. There are no whatsoever references to fault. Whereas if you look into the UNIDROIT principles, they use the term termination instead of avoidance, so we have mixing up of terminology. So the UNIDROIT principles take fault as one possible criterion to define fundamentality of the breach. You cannot say, okay, for a definition of fundamental breach, we rely on the UNIDROIT principles and there is fault, because this goes strictly against the CISG. So I think because there are so many, differences in essence, they may appear in a subtle disguise, but they are differences between civil law and common law. And where the UNIDROIT principles are more civil lawish, certainly, than the CISG, and you would bring in approaches that are not fit to interpret the CISG. So that is why I think the UNIDROIT principles should not be used to interpret the CISG. What I use the UNIDROIT principles for is that they may be a representation of comparative law, because they too took into account the different approaches of the different legal systems and came to a conclusion. And that may be used just as I may use the different domestic legal systems on a comparative basis. I'm through? Okay?
I know that Marko cannot say that you are through. I mean, nobody would dare to say that. But I think it's time for a coffee break, and we are privileged to have you in the afternoon as well. So we're happy to continue with what you have prepared next on these slides.
Well, then I will just start the first 2 slides of my conformity. Well, up to you. Do you want me to continue this afternoon, or should we turn to conformity of the goods?
I think we will.
Both are useful, but I mean,
maybe I think priority is to our mooties, huh? And you want to hear something about gap filling and interpretation of the contract. Okay, then we do that. Okay, thank you.
Thank you very much. Thank you very much for this first half of a very energetic, insightful, and thoughtful presentation. And we are all eager to hear the sequel in the afternoon session.
Okay.
And now, since you received a lot of food for thought, it is time to get some coffee as well. The coffee will be served in front of the conference hall, and I urge you to be very punctual because we will continue in 15 minutes sharp. So enjoy your coffee break and be back in 15 minutes.